Welcome back to the Deep Dive, everybody. Today, we're taking a look at a Supreme Court case.
That's right. We're diving deep into a decision that really gets to the heart of who's responsible when false information is spread in the world of investments.
We're talking about the case of Francis v. Lorenzo v. Securities and Exchange Commission, and it's a fascinating look at securities fraud.
Definitely. I think a lot of folks might find the outcome of this case surprising, so let's break it down and really understand what the Supreme Court decided and why it matters.
Sounds good to me. So, to set the stage, this case involves, well, as the name suggests, Francis Lorenzo, and he's basically fighting the SEC, the Securities and Exchange Commission, which is kind of the watchdog for our financial markets.
Right. And the core issue here revolves around something called securities fraud, which, simplified, is basically when someone intentionally deceives others in order to gain financially in the stock market or other investments. It's a serious offense.
Absolutely. And in this case, the big question the Supreme Court had to grapple with was whether someone can be held liable for securities fraud if they pass along false information, even if they didn't actually create that false information in the first place.
Exactly. It's about, where do we draw the line between being the originator of a lie and being someone who helps spread it? And in the case of Lorenzo, the Supreme Court came down pretty firmly on the side of saying that just passing along bad information, knowing it's wrong, can get you in serious trouble.
So let's get into the specifics. The Supreme Court ultimately held that Lorenzo could be held liable for sending out emails to potential investors that contained false financial information, even though he wasn't the one who actually wrote those misleading statements.
Right. And this was actually kind of a reversal from what a lower court had decided. The lower court had initially said that, Lorenzo didn't write the lies, so he couldn't be considered the maker of the false statements.
So it was all about him just sending those emails, right? The lower court said, hey, just sending it is a deceptive act in itself.
Yeah, and to really grasp how this case played out, we need to go back a little bit. There was a previous Supreme Court case called Janus Capital, which basically said that when you're talking about this specific part of securities law, Section 10b and Rule 10b-5b of the Securities Exchange Act, only the person or entity that actually makes a false statement can be held liable under that specific provision.
So Lorenzo's legal team was really hammering that point home. They were saying, look, the lower court already agreed Lorenzo wasn't the maker. You can't just ignore the Janus decision and find him liable under other parts of securities law. They really wanted to keep that maker definition front and center.
And their argument went even further. They argued that those other provisions, like Rule 10b-5a and C and Section 17a1, are designed to deal with deceptive conduct, which they claimed is fundamentally different from just making a false statement.
So they're basically saying Lorenzo might have made a mistake, but it wasn't intentional deception, right?
Exactly. And they were concerned that if the Supreme Court said Lorenzo was liable here, it would basically render that whole maker distinction in Rule 10b-5b useless. What's the point of that specific rule if you could just go after someone under these broader provisions anyway? They felt it blurred the lines between being primarily responsible for a lie and just being someone who, maybe unknowingly, helped spread that lie.
So they were painting Lorenzo as more of a middleman, just relaying information and not intentionally deceiving anyone.
Precisely. They even went so far as to say that Lorenzo was simply a conduit, just passing along information from his boss, who they said was the real originator of those misleading emails.
So from their perspective, hitting send on an email shouldn't automatically make you liable for securities fraud, especially if you weren't the one who came up with the false info in the first place.
Now, the SEC obviously disagreed. They argued that Lorenzo's act of knowingly sending out those emails with false financial information was in and of itself a deceptive act, and therefore he was liable under those other parts of securities law, Rule 10b-5a and C, as well as Section 17a.
So for the SEC, it was all about Lorenzo knowing the information was bad and still choosing to pass it along.
Yeah, they kept bringing up the fact that Lorenzo himself had admitted he intended to defraud those potential investors. And for the SEC, that admission of intent, that scienter, was crucial.
The SEC also cited another case.
Right. They pointed to a previous Supreme Court decision, Central Bank.
Yeah.
Basically, Central Bank established this idea that if your actions line up with the specific language of a provision in securities law, then you are a primary violator of that provision. They were like, look, Lorenzo's actions directly fit the description of what constitutes a violation under these other parts of the law, regardless of whether he made the false statement.
I really wanted to emphasize that.
For sure. The SEC also argued that the concept of conduct can definitely include making statements, and that Lorenzo's act of sending those misleading emails straight to potential investors was the act itself. Like, the sending was the problem.
It's interesting how much hinges on the interpretation of these legal terms. Conduct, making a statement, deceptive act. It can all get pretty nuanced.
Absolutely. And the SEC even brought up another part of the law, Section 17A2, which specifically forbids obtaining money or property by means of untrue statements. Even though Lorenzo wasn't actually charged under this particular section, the SEC argued that it was still relevant because it didn't seem to have that same maker requirement that the Janus case applied to Rule 10b-5b. They wanted the court to see the bigger picture, basically.
So the SEC was really trying to drive home this idea that if Lorenzo wasn't held liable, it could create a dangerous loophole in securities law. Imagine a scenario where high-level executives, maybe willfully ignorant of the specifics, just tell their subordinates to spread false information to investors. The SEC argued that letting Lorenzo off the hook would set a bad precedent.
Now, during the actual Supreme Court hearings, you could tell the justices were really wrestling with all these arguments. They peppered both sides with questions, really trying to tease out the nuances. They focused heavily on the distinction between making a statement and engaging in deceptive conduct. Like, is just sending an email with info, is bad, actually a deceptive act in itself? Where's the line?
It's interesting how much the justices seem to rely on these hypothetical scenarios. What if this happened? What if that happened? They really use those thought experiments to try and figure out how a decision in this case might play out in the real world.
Yeah, they're trying to see around corners. And the justices also dug deep into how the Janus decision might affect the interpretation of other parts of securities law. They spent a good deal of time trying to figure out how all the different subsections of Rule 10b-5 and all the different parts of Section 17a work together, how they all fit within this complex legal puzzle.
And as you mentioned earlier, Lorenzo's admission of intent, that scienter, was a huge focus. If he hadn't admitted to intending to defraud investors, who knows how this might have played out?
It's hard to say for sure, but it was definitely a key element. The justices really wanted to understand where the line is between primary liability being directly responsible for the fraud and secondary liability, helping someone else commit fraud. It's not always black and white.
And the way I see it, that's what makes this case so significant. It really highlights the complexities of assigning blame and responsibility when false information gets spread around.
Absolutely. Okay, so now it's time for our favorite segment, the 10th chair.
Our 10th chair segment, where we put on our imaginary judicial robes and step into the role of a Supreme Court justice to offer our own take on the case. So if you were the 10th justice, how would you have ruled on Lorenzo?
That's a tough one. Well, what I fully appreciate the maker rule the court laid out in Janus, I think in the end I would have sided with the majority and upheld Lorenzo's liability.
Interesting. Why is that?
Well, that admission of intent, the fact that he knew he was trying to deceive those investors, really sways me. Even though Lorenzo didn't write those misleading statements himself, the fact that he sent them out, especially from his position of authority, and the fact that he encouraged investors to contact him directly, well, that tells me he was more than just a passive middleman. It suggests a much more active role.
I see your point.
To me, letting people knowingly pass along fraudulent information and then claim they're not responsible because they weren't the original maker would create a massive loophole in securities law. And frankly, that loophole could be exploited by all sorts of bad actors.
That makes sense.
In my view, the focus should be on the deceptive nature of the act itself. The intentional spreading of false information to mislead people and not getting caught up in these, hyper-technical debates about who actually wrote the words. I think that approach aligns much better with the ultimate goals of securities regulations.
Absolutely. Which are, at the end of the day, to prevent fraud and protect investors.
Exactly.
Well, that wraps up our deep dive into Lorenzo v. SEC. It was a complex case, but a truly important one. What are your final thoughts?
For me, this case really highlights the ongoing challenge of interpreting and applying securities laws in a constantly evolving financial landscape, especially in today's digital world where information spreads so rapidly.
I think you hit the nail on the head there. This case really makes us reconsider how we define deceptive conduct, especially when it goes beyond simply making a false statement.
Yeah. It raises a lot of thought-provoking questions about individual responsibility, corporate accountability, and how we ensure a fair and transparent marketplace. Questions I hope we can all continue to ponder.
I completely agree. Thanks for joining us for another deep dive. If you enjoyed this discussion, please let us know what other complex legal or financial topics you'd like us to tackle. Keep learning and stay engaged.
And remember, we always welcome your questions and feedback. Keep those coming.
Thanks for listening, everyone. We'll see you next time on The Deep Dive.